the ponds and all that in that area. So the fish farming, which was the mainstay of the community, suffered a lot, and the farmlands they couldn't plant. So they had to take an action against the oil company. When the issue of um, non-compliance with the environmental impact assessment was raised, they feigned, of course, a kind of defense that they did something similar to it. But of course, by the time the records at the Environmental Impact Assessment Office was checked, there was nothing like that. So now we are in negotiations. This could have been avoided, but they thought the members or the people of the community will not be able to fathom or lead their sufferings in the community to them. Unfortunately, they probably had one or two persons that were educated who was able to raise these issues, and they got a lawyer to enter negotiations with them. So because of their failure to comply, now we are there having that negotiation. And of course, they must pay the compensation. In the construction sector, you need permits. Yeah. For the different kinds of land allocation you have in the different parts of the states, could you please take me back to the page that we're now? For different parts of the states, you would understand that it is only some kind of constructions that are allowed in some particular areas of the state. In some areas, they say something like commercial, some residential. You must get your building plan approval for these different places so that the appropriate construction is done in that place. You probably might have heard that for different kind of developers, they have suffered some setback due to their failure to get necessary permit. Not long ago, you heard about some demolitions of some constructions in Lagos. Yes. Why was that done? Because the constructions were done on probably waterways, under high tension electric lines, for different other reasons. If they had gone through the appropriate process and been given the appropriate building plan approval, as a permit, license to construct, they wouldn't have suffered such fates. That is why it is very important. You can imagine someone who has spent his life savings on a construction only to find out that he never got the permit, necessary permit, and the building has to go. It's going to be a real sad loss. And if there was a developer who championed the construction, everybody will go after him. Everybody will go after him. There was this developer in Lagos that suffered such, where he had built several houses to different people he had collected money from, but at the end of the day, it was realized that he didn't get the necessary building plan approval. The buildings were demolished, so he is now liable to the different persons that subscribe to his construction. So in addition to the oil and gas and construction industry, several other businesses also require permits, licenses, and they need to comply with several other things. Next slide, please. Yes. So while you have done your compliance and you already know you have the necessary licenses to carry on your business, definitely you don't do your business on your own. You don't just open your business and sit down there hoping it's going to run and earn itself. You enter negotiations, you meet people, your customers, your clients. Of course, you make your introductions. That is, you let them know what kind of business that you're doing and what service you're providing for them. Then after that, they let you know what they want. Then the negotiations starts. That is, I'm going to provide this service for you, but this is how much I think I'm going to charge for it. They come back to you to let you know, like, we think that probably is too high. Every business person must negotiate. It's too high. I think this is the amount we would like to pay for that. Then we move on to understandings. After you have an understanding in that regard, this should lead to what we call non-circumvention and non-disclosure agreements. We call it NCND. Why do we have this? At the time you're having these initial meetings, you normally disclose the secrets of your business. What makes you stand out from the other persons who are carrying out the same service? So the danger is this: when the other person, the other party, already has this information, there is always the fear, or it has even happened a number of times, that this other person would carry that idea, give it to that other organization that provides a service for less, and let them know, this is what I want you to do extra at that same less price, and deprive you of the income that you're meant to earn in that regard. Because you have freely disclosed information to them, it is difficult, or you have no right of claim because you freely give them the information without any binding agreements to prevent them from making use of the information. So with this, it is important to sign or execute a non-circumvention, non-disclosure agreement. A lot of people who didn't do this at the inception of negotiation have lost out several times, several times. I've been with clients who have suffered this, and we are still trying to deal with the loss which is sustained in this respect. Yeah. These different understandings after the NCND will lead to what we call Memorandum of Understanding. The Memorandum of Understanding is this: Mr. A and Mr. B have met. Mr. A provides this service. Mr. B wants this service. Mr. A and B have agreed to do this and that and that. At the end of the day, this is what they need to earn, and this is how they will share the profit at the end of the day. Or this is the service you're going to provide, because we have provided a client who is going to enjoy that service. It depends on the nature of what kind of negotiation you're having or the service provided. So sometimes parties could decide that the memorandum of understanding could be binding or non-binding. Considering the nature of the agreement, if it would require one of the parties to make some financial investment, we would consider that binding, because it has made me to incur some financial investment. So if at the end of the day, they now say, I don't feel like doing it again. Okay, Mr. A, you have made me incur $1 million because of our memorandum of understanding. So I need reparation. I need compensation for the $1 million I've incurred. Because if I did not enter that memorandum of understanding with you, I'm not going to incur any $1 million investment. So depending on the nature of the agreement, it could be binding or non-binding. So after you have this memorandum of understanding and parties actually comply with it to get to the next stage, we now have what we call definitive agreements. When you complete final negotiations, it is important you reduce it into what we call definitive agreement. So this definitive agreement is what will guide the parties in the transaction which they have entered. Mind you, in some parts of Nigeria, they don't enter agreements when they are entering transactions. In fact, in some parts of the world. And it is based on the moral values that exist in such places. But mind you, even in addition to the moral values, some people may not understand what's required to carry on some particular kind of business. But the most important part of everything is utmost good faith. The fact that definitive agreements were signed or executed by parties does not mean that things cannot go wrong or a party might not decide to comply with the agreement. But what it does is it guides what happens after one party has breached the agreement. It provides certainty. Then, if you even require the finance of a financial institution, a bank, if there's no agreement, I don't think they'll be willing to give you any finance. But where the agreement is there, they know, okay, this is what guides the party. So if something goes wrong, this is a fail-safe system where we can recover whatever finance that will provide to this person. So these are the different reasons for the agreements, definitive agreements that are entered. Next slide, please. So you realize that from the conversation that we've been having, in as much we have not made it so legalistic, the different step to be taken requires the guidance of a lawyer. And of course, a lawyer who is vast in that field. So in engaging your lawyer, you could engage your lawyer on retainership. You could engage your lawyer on ad hoc basis. But whichever one you choose, it is highly recommended that you engage a lawyer. And I've seen several situations where business owners would reveal to you after they've gotten themselves into a very tight end, that is in a big problem, that they would tell the lawyer that the agreement was very simple, but he breached it. But by the time you look at the agreement, there was no fail-safe system, nothing to protect the parties, nothing to guide detailed areas of the transaction. Mind you, in as much as agreements are drafted in English language, and you think anybody that understands the English language would know how to draft an agreement. No, it doesn't work that way. The experience of a lawyer haven't actually had to intervene in several disputes on transactions, assists him in suggesting the right clauses to put in any agreement which provides for you based on the nature of the transaction you're entering. Based on the nature of the transaction that you're entering, he's able to advise you. So when it comes to retainership can be per annum, be per quarter, per month. On the outset, it might seem expensive, but in the long run, it is cheaper. Why retainership? When you have a retainership with a lawyer is prevented from taking any case from any other client that would affect your interests in any way. So for that, you charge an amount of money, which would run, like you can see, per annum, per quarter, per month. And when you're on retainership, you have a right of audience from your lawyer at short notice because you're paying per annum, lawyer is good for you. Then your lawyer also grants you credit on services and discount on the services that is being provided. So, but of course, every cost that is to be borne in respect of whatever instruction you give your client under retainership is to be borne by you. For example, if under the retainership, there are cases in which your lawyer needs to defend you in court, travel on your behalf, pay statutory bills on your behalf, you as a client are to bear the cost of that. Bear the cost of that. So at any point in time, depending on negotiation you have with your lawyer, it is always advisable to go for the retainership. On the ad hoc basis, what happens is that you rush to your lawyer or a lawyer, you tell him, oh, I'm in this issue, in this problem. Because you're not on retainership, you take a second fiddle to the customer who is on retainership. So for him to pay attention to your complaint that takes a second fiddle role, you have to pay more because what you pay for and your lawyer is his time. You have to pay more at that time. But if you had been on retainership, all you have to do is put a call through and he attends to it. So that is the way it works. But for whichever method that you choose, it is highly important that you engage a lawyer. You must have that you call, this is my lawyer. But very importantly, you have to pay your lawyer because your lawyer can only advise you appropriately, deal with your queries if you pay him. You will not expect a lawyer to have 10 files in front of him, then he will now pick the file of the client who hasn't paid. No, he goes for the file of the client who has paid well first, deal with it before he moves to the next one in the order. And he may deal with the one that has not paid if he likes, depending. But it's always advisable that you enter a good negotiation with your lawyer, agree decent fees, and pay him. He'll do the work. He will do the work. Next slide, please. So, and as soon as you engage your lawyer, you have to make sure you carry your lawyer along in your business dealings. Make sure you carry your lawyer along in your business dealings. Do not, after you have entered transactions, now call your lawyer like, oh, I finished this transaction today. There was no need to call you. In as much as in normal life, we don't pray that we'll get into problems or have difficulties. But of course, you there's always a chance something goes wrong and it's difficult for a lawyer to manage if something happens. I will share with you a situation I had before with a client. The client had an oil field, the location of an oil field by NNPC. After I got the allocation of the oil field, he now entered an oil field development agreement with Shell. At the time he was entering the oil field development agreement, he did not involve his lawyer because he felt it would be too expensive to get the lawyer involved at the time. So he entered a 350-page agreement. And what moved into that agreement was that somewhere along the line, he's going to earn $50 million, but he didn't want his lawyer to hear because most likely his lawyer will say he's getting a percentage of the $50 million. He signed the agreement. Then about 2 years down the line, he just puts a call through to his lawyer and says, lawyer, I have this small issue I want you to look at. You know, some people are trying to be smart with my business and this and that. I said, okay, well, what's the issue? So apparently, Shell had taken him to court. In the oil field agreement, what was to happen is this. He was to give Shell control of his oil block. Shell will spend their own funds in developing the oil block until it turns to to get an oil mining license, that's commercial quantity. Then they will pay him a sum of $50 million. Then they will enter other agreements when it gets to commercial quantity. But it was subject to some other terms. So because he just saw $50 million on the agreement, he signed, said, I won't let this lawyer take my money. Then It was only after he was making a claim for his oil block and saying Shell had no right on it. Shell now took him to court, saying that there were some things in the agreement. If it hasn't been done, then we don't have any duty to pay him any amount of money, including the 50 million US dollars. So the case had been on in court for some months when he now realized that Shell kept on doing business on the oil block and he wasn't earning anything. That was when he now remembered about me as his lawyer, and he now brought me into the action. And the first thing I exclaimed was, you mean you signed a 350-page agreement without involving your lawyer? He said, I'll just consider, people charge a lot and this is, and I said, so now you have to pay more. He had no choice but to agree. Fortunately, we saw some loopholes in the agreement, which we took advantage of and were able to discharge. We were able to discharge the injunction they actually got against my client on his oil block. So that is a classic example of why you need to involve your lawyer at any point in time that you're entering these transactions. But of course, again, there's the caveat. The fact that you have a lawyer does not eliminate legal issues in business, but reduce its frequency and cost of management. So that is it. It's not that we can't control the mind of the other party, but we can control the damage that such issues will cause on your business. So that's the way things stand, as it is. Next slide, please. So I think that's basically brings us to the end of the presentation. We are now open for questions and answers. Thank you very much.
Thank you very much, sir. We really appreciate your time. And I must say that you have such a captivating voice that has indeed made it so pleasant listening to you. I must say that you had such a great and amazing session. Thank you so much, sir. Really appreciate you. And right now it's time to take questions. We hope that we have some questions that came in during the course of the registration, and we'll just be reading up that so that you could attend to that. And if we still have time, you go ahead to answer some more questions. So I'm going to hand over to Mr. Rilasso the Kong to take over the question and answer session. Thank you very much.
Once again, good evening, our highly esteemed SAN. Thank you so much for blessing us with your years of experience. I can imagine having to compress many years of practical business experience into just a few minutes. I could only imagine how hard that must have been for you. And that's one of the reasons why we have a question and answer sections, because quite a number of things have been covered actually, but sometimes it's always good to reiterate, just to drive the point home, just to also offer some form of context into some issues. One of the major questions that kept popping up is, how do you effectively structure your business for exponential growth? You talked about small businesses, how you can also run as a corporation. Looking at what we have, a lot of people in this part of the world run businesses because of circumstances. So if that simply means if they had their way, they most likely would have probably ended up as just corporate people, 9 to 5, just work for somebody. But the way the system is, now they are stuck, they have to survive, they have to make progress. how do they structure that business for efficient growth?
Okay, thank you very much. Structuring your business for growth, I would say, will be determined by the nature of business, but it is important to actually do so. For example, some people receive personal funds in company accounts. Some people have lunch and pay for it from company accounts. It is not meant to be so. In that way, you erode the capital, profits, and expenditure of the company. It is now difficult for you to be able to identify if your company is making profits or losses. Some properly structured company will understand the nature of bank accounts that they are meant to have, whether it's a savings account or a current account, depending on the nature of their business, the income that they are making, and the expenditure that they are making. So first things first, separate personal transactions from business transactions. That way you are able to monitor the growth or the loss that your business is sustaining, which will now advise you as regards the next step that you're meant to take. For every person, when you are issuing a bill to a customer, make sure you send an invoice to that customer and have files, create files for them. They don't always have to be physical files. They could be soft copy files. But make sure that whatever time you have to go to these transactions, the records, it is always there and you have them and they are clear. This way, you are even able to audit your transactions. It makes it clear for you that this is what I'm doing and this is what I'm not doing. Then in addition, when an investor is seeking a business to invest in, your business would look attractive because of your documentation and the proper record that you have. But if you just say, oh, I'm a fashion designer, I've been in this business for 15 years. Okay, can I see your documentation to be able to appreciate the growth that you've enjoyed and the expanse of a clientele? And you start going through your phone book. I used to call this person that he sent me this. There's this WhatsApp, there's this picture of this design I sent to this man. No, nobody wants to invest in you. You found disorganized already. I'll just say, hello, thanks for chatting with me. I move to the next one. So that's one way out of that.
Okay, thank you very much for that detailed explanation. We're so grateful. The next question is, how do you know how much your tax is and how do you file your taxes?
Okay, thank you for the question. The tax man is always the best, in the best position to advise on how much tax. But be that as it may, we have guidance in the tax laws. That tells you on what you pay tax and on what you do not pay tax. There's clear guidance in all that. So it's good for you to get your lawyer or tax consultant. As a lawyer, I also work as a tax consultant where I advise clients that, oh, you're not entitled to pay this kind of tax. Not too long ago, a client of mine who happened to be a mortgage bank was asked to pay what they call value-added tax. They were charged about over 300 million in value-added tax. So they advised 300 million. Where are we going to get 300 million to pay? I said, well, if you have to pay tax, then you have to pay. But I'll look at this provision for you to know if it covers you. I looked at it, and by the language used in the word, it appeared that because their big business is mortgage business, they are not required to pay value-added tax. So what did we do? We challenged this value-added tax at the tax appeal tribunal, and we succeeded. And they were not required to pay anything. They went on appeal, and we also succeeded on appeal. We don't know if they'll be interested in going to the higher court now, but whenever they